Hi, welcome to the Retail Lawyer. So I'm here today to talk to you about limitation of liability. Um, as you know, these little video segments are really geared towards small business owners generally, but many of the people watching are going to be small business owners of various types. So I wanted to talk about a foundational item, which is setting up your business. Many people set up corporations, they set up limited liability companies. Some people work under sole proprietorships. Now, sole proprietorships are kind of outdated. People still do it if you're a smaller business. If you're in certain industries, it's very common. Like if you're a real estate agent, you kind of work for yourself and everything's self-employed and you don't really formalize anything. But you put yourself at risk when you do that. And that's why most people that are moving into the business space, they set up an entity, whether it's a corporation, a limited liability company. Sometimes there's limited partnerships, but that's usually more for tax purposes and handled a different way. So there's two reasons why people generally form limited entities, whether it's a limited liability company or a corporation. And that's one, for tax purposes, and two, to protect your personal assets. Now, for the tax purposes, I highly recommend, and I really think you need to talk to your accountant, talk to your financial advisor, get an understanding of what structure makes the most sense for tax purposes based on your overall assets. I'm going to move you a little closer because I feel like you're far away. Based on your overall assets, based on what state you're in, based on the type of business that you're in, based on how you want to disperse your funds, etc. So you're going to talk to your accountant, and you're going to find out from them if they have a preference for a corporation or an LLC. You'll find most of the times that your accountant will have a preference. And even if you form an LLC, you can choose, there's a box, an election form that you could check the box and choose to be taxed as either a partnership or a corporation. So that's one piece of the puzzle, and definitely have that conversation and then inform your attorney who's performing the services to create the entity what that information is and where your accountant would like to have this done. Now, sometimes accountants will form the entity themselves. Sometimes people will take it upon themselves and use one of those online services, which I won't name because I don't want to get into trouble. But be warned, when you use those services, you don't always get everything that you need. And this is anecdotal. I can't say this across the board, but anecdotally speaking, I can tell you that I have one set of problems that happens when people use the online services, and I have a different set of problems that either accountant or online services. So let's start. So if you use the online services in New York State, and again, I'm limiting this to New York State right now, and you're forming an LLC, I can't tell you how many times I've had, and I just rolled my eyes in a big way on purpose. I've had so many clients come to me and they formed it online, and I check on the registry and okay, yeah, it's technically filed with the state, but you didn't complete the process. You didn't do the publication. And in New York State, to do an LLC, you're supposed to publish in 2 periodicals in a certain way, in a certain manner, over a certain period of time. And people don't do it because what happens when you look at these online services, there's a little asterisk that say, oh, you might need to do this, but then doesn't explain to you what it is or how to do it. So you got a problem there. And then you can't, if you haven't done that, that could potentially prevent you from defending yourself in court. It could run you into issues of having standing to act in court. You could be, accused of not fully forming your business, and that could create other issues, which is exactly what I'm going to talk about, which is the issues that if your entity is found to be lacking. The other piece of it, and this all falls into what we call corporate governance, corporate housekeeping. There's different phraseology around it, and it doesn't have to be just for corporations. It can be for limited liability companies as well, is that your paperwork's not completely done. Yeah, you filed a piece of paper with the state, all well and good, that's lovely. But if you're a corporation, you're supposed to have bylaws. You are supposed to have an initial shareholder consent or board of, initial resolution naming your board. You're supposed to have an initial board resolution or consent naming your officers and agreeing to the bylaws and authorizing parties to open up a bank account and to take certain material actions to the benefit of the business. Then you're supposed to do that on an annual basis. And you can have in-person meetings, you can have telephonic meetings, you can have written consents in lieu of meetings. There's a lot of different ways you can do it. And now obviously with video conferencing and Zoom being so big, you have your video conference instead of an in-person meeting. Now this is for private companies. Public companies have their own rules under the SEC. I just want to make that clear. I'm talking about your small mom and pop, smaller business, getting things under privately held is really the key phrase here. So, and then for the limited liability company, I talked about the publication issue, but you're also supposed to have what's called an operating agreement. And the reason why a lot of businesses, like in the private equity space, they choose LLCs because they like the flexibility of an operating agreement. Instead of the statute deciding what is and how it works, you negotiate that and put it into your operating agreement. And there's a lot of flexibility there, and there's a lot of deference given to the operating agreement and its terms and provisions. If you don't have an operating agreement, then you fall back onto statutory rules, which may or may not be beneficial to you at the time that you're having a dispute. So that's just setting it up. And how are you going to set it up and making sure you set it up correctly? And that's, once you do that, again, within this mindset of protecting your assets, you have to do those things. You have to set up the corporate governance. You have to set up the foundation of your business. And then you need to take additional steps as you move forward, not only trying to meet your business goals, which obviously should be your priority, but you need to do these things, these corporate governance items, to maintain the distinctiveness of your business as opposed to you, the individual. And the things, basic things here, okay? Have a bank account that is just for the business, and only business monies go in and only business fees are paid from it, right? Separate from your personal banking. Have an insurance policy separate for your business if it's applicable for your type of business. Do the corporate housekeeping, all those items that I just mentioned. Arm's length transactions, and then do the consent. So now here's the thing. I was just mentioning consents and resolutions. Now it's standard that it's done, and it's required to be done for boards of corporations. But many times, limited liability companies will take on those standards so that they too will document material decisions that were made for the benefit of the business, and to authorize people to act on behalf of the business. And it helps because it sets the stage, it tells the story. It makes it very clear that the business is a separate and distinct entity from the individual or individuals who formed the business. And so I have, as usual, and I just want to say this so I don't forget, I have my usual little one-pager here with a breakdown of some very simple things to think about to make sure that you're doing the right way to get you going. And what I also talk about here is where the risk is, down here at the bottom, right? I have two definitions down here about legal doctrine. Sorry, I had a blank for a second there. Legal doctrines, whereby people can say, that business is not really a separate entity. It's quote unquote the alter ego of the shareholder. Or because it is a fake business that's set up to divert funds or try to hide assets that rightfully should be part of the business, or there's a commingling of management between parent and sub, or between affiliated entities. It's the same ownership, it's the same bank accounts, it's the same management, that really the assets should be commingled when such a debtor is going after them. So the concepts are called alter ego and piercing the corporate veil. And so, for example, alter ego is a legal doctrine whereby the court finds a corporation lacks a separate identity from an individual or corporate shareholder, resulting in an injustice to the corporation's debtors. Finding alter ego gives the court opportunity and cause to pierce the corporate veil and hold individual shareholders personally liable. There goes your house. Okay. Secondly, so let's talk about, so that's one type of doctrine. So then there's another one, and you can argue these things together. You don't have to say one or the other in the alternative. You can argue them together in the alternative, right? Then you got piercing the corporate veil, a legal decision to treat the rights and duties of a corporation as the rights and duties of its shareholders. Usually a corporation is treated as a separate legal person, which is solely responsible for the debts it incurs and the sole beneficiary of the credit it is owed. But if you pierce the corporate veil and you go up, and it's usually the top 10 shareholders, right? You can go for all their assets, depending on what's going on. So let me give you some big examples, okay? So for example, I was general counsel at Sims Clothing years ago, and I came in at a time where they had purchased the assets of Filene's Basement out of bankruptcy. And I could talk about this because it's public record. There's a big case about this. And what ended up happening was they realized that the assets for Filene's Basement were not as strong as they had hoped, and they didn't have the wherewithal to really rebuild that business. And so they decided to spin it out and put it into bankruptcy. And with the idea that Sims was going to survive as a separate separate business. But what happened, unfortunately, before I got there, and they had already gotten the assets, they already had started certain processes and protocols where the distinctions were just not as good as they should have been. And so unfortunately, what ended up happening was they were able to show common management without proper documentation and money movement, common ownership. They were able to show a lot of things that unfortunately should not have been the case. And what happened in that court proceeding was that the filings bankruptcy's creditors, through motion practice, dragged Sims into it, and it bankrupted Sims as well because their assets became part of the discussion and part of the settlement procedure because of what started at filings level. So that's one example. Another example, and I know I brought up Starbucks, another one, but this is a Starbucks example, I'm sorry. Starbucks had purchased Teavana. I don't know if you remember Teavana. So it's the tea version of Starbucks. And they were realizing at some point, and I'm not privy obviously to internal discussions there, but at some point they realized that the Teavana stores weren't really necessary, that they could add a Teavana section to the existing Starbucks. So they went and tried to close down a number of the stores, and they had reached out to landlords and said, hey, we are shutting down this part of our business. We're going to be terminating the leases, yada, yada, yada. The landlords, rightfully, and there's a case out there, but I won't get into too much of the specifics, but one of them in particular came back and said, excuse you, but you accepted this lease. Teavana is not a separate company. It is a division of Starbucks, not separate, part of. And you can't walk away from these leases just because you feel like it. And you can't put Teavana into bankruptcy because it's a division of Starbucks. And there was litigation, things going on in the first round anyway. And I don't know actually how it all ended, but the first round went in favor of the landlord. And it basically said, no, look, it's same management, same business, no separate bank account, no separate entity. You need to keep paying. And this was millions of dollars, and they had already closed the stores. And so they were forced to pay money to reopen some of these stores. And obviously it turned into a big negotiation because the costs got prohibitive. But this is my point. Big players make these mistakes as well as small players. And what ends up happening with the small players is that from the go, they're not doing it right because the corporate governance, the corporate housekeeping, little ticks and tads and steps aren't being done appropriately. So I'll give you a personal example for myself. So I have a PLLC, a professional limited liability company. I don't pay my home mortgage or my student loans or my utility bills out of my business operating account. I have a separate business operating account that it collects all the revenue. It gets processed through there. I pay the office lease from there, my rent every month for the office. I pay my professional liability insurance and those kinds of things out of and office supplies, etc. I pay myself every month a check. I write myself a check as my salary, and that goes into my personal account. And from my personal account, I then pay my personal bills because there has to be that step in between. It sounds like it's redundant and a pain, but it's setting up that distinction, and you need to think about the distinction. So protect your assets, do your housekeeping, it's a good thing. Talk to your accountant, make sure that you're set up the right way. Talk to your lawyer if your lawyer did it. I'm sure if your lawyer did it, I think you're probably in better shape, but that's me being a little subjective. But make sure you've done these things. They're easy things to do, and protect yourself. And again, if you want the one-sheeter, contact me through LinkedIn or contact at the Retail Lawyer, or contact me at email laurabrandtesq@gmail.com. Protect your assets. Thank you. And how do I turn this thing off? One of these days I'll do this appropriately, and you won't all giggle at me about what an amateur I am.